Welcome back to panel 2 for the Texas Chapters Conference. We're scheduled to begin. If you refer to your itinerary, this is the panel focused on criminal justice review, President Trump, Sessions, and the states. As a former Assistant United States Attorney, I'm happy to welcome to Fort Worth your United States Attorney for the Northern District of Texas, Erin Nealy Cox.
Good morning. Thank you. I'm Erin Nealy Cox. I'm the United States Attorney for the Northern District of Texas. And I want to thank the Federalist Society, and especially Diane Kozub and Matthew Katzmarek, both alums of our Fort Worth office, for hosting and organizing this event, and for inviting me to participate in this distinguished panel on criminal justice and criminal justice reform in this administration. In a moment, it will be my privilege to introduce to you Judge Reed O'Connor, a distinguished member of the court here in the Northern District of Texas. Judge O'Connor will then introduce our other distinguished panelists. But before that, I'd like to offer a couple of brief preliminary remarks to frame the discussion this morning. When I think of the Federalist Society, I think of this organization's commitment to fostering debate about first principles in the law. I think that this commitment is one of the Federalist Society's signature contributions to our profession. It has carved out space for real conversation and real disagreement about legal issues. For decades, the Federalist Society has created opportunities for practitioners and judges and academics and students to wrestle, not with straw men, but with strong, reasoned, and principled versions of legal arguments. Often, as we all know, the debates that the Federalist Society sponsors are between the right and the left. And what's unique about today's conversation is that it's primarily a conversation among conservatives, or perhaps more accurately, conservatives and libertarians. The fact that criminal justice and criminal justice reform is a topic of intramural debate within the Federalist Society family doesn't make it any less important. As any parent knows, the conversations with family that happen around the dinner table are often the most important and sometimes also the most heated. But the reason these fault lines endure over time is that there's a basic tension between, on the one hand, those conservatives who believe in being tough on crime by prosecuting offenders to the fullest extent of the criminal law, and on the other hand, those who believe the criminal justice system is basically broken and in need of reform. That's the tension that we're going to explore this morning, and I trust both of those views are well represented here today. From my perspective, this is a particularly important conversation because it comes at a time when both the President and the Attorney General have made it clear from day one that efforts to combat violent crime are a top priority in this administration. In my tenure as the United States Attorney, we have renewed our commitment and focused our resources on the problem of violent crime in the Dallas-Fort Worth area and across the Northern District, with the goal of vigorously and effectively prosecuting violent offenders who victimize hardworking, law-abiding citizens in our communities. But violent crime is also a touchstone in the criminal reform debate. And there are differing opinions, including, I suspect, those on this panel about how to address that problem and others like it. But before I turn it over to Judge O'Connor, I'd like to offer two basic comments on how we at the United States Attorney's Office are thinking about and engaging on some of these issues. First and foremost, I believe that charging decisions matter. Oftentimes when we speak of reform, we always speak of the end of the process: sentencing, incarceration, reentry. But I'd like to focus on the beginning. Every first-year law student knows that federal courts are courts of limited jurisdiction. In the same way, both federal criminal law and federal criminal prosecutions are jurisdictionally limited, both by the United States Constitution and the United States Code. I believe deeply that it is the job of every federal prosecutor to understand and to honor those limits at each and every stage of the case. When I became the United States Attorney, returning to government service after spending time in the private sector, I was honored to be asked to serve as a member of the Attorney General's Advisory Committee. And as such, I also serve as the liaison to the Office of the Solicitor General. And what I learned in some of my preliminary discussions with our great Solicitor General is that there is a body of 11 cases over the last 5 years where a United States Attorney's Office has obtained a conviction in the district court, won and kept the conviction in the circuit court, and then lost 9-0 in the Supreme Court. 11 cases. And I wanted to find out why, because I assure you, no prosecutor wants to become a member of that 9-0 club. Which is, why is it that we have a track record of winning twice and then losing unanimously in the Supreme Court? And what I learned when I started to dig in with some of my colleagues is that 9 of those 11 cases are cases involving statutory interpretation. They're cases where at the end of the day, the Supreme Court has turned to the Department of Justice and all 9 of the justices have said, you're reading the statute wrong. So put in another way, in the overwhelming majority of cases where the criminal prosecutor suffers unanimous Supreme Court loss, it's because we're not being good textualists. And when we're not being good textualists, we make errors, particularly at the charging stage. So the tools of statutory interpretation that the Federalist Society has championed for decades are not just for Article III judges, or appellate lawyers, or Supreme Court clerks. These are tools that are critical to the proper enforcement, not the over-enforcement, but the proper and vigorous enforcement of federal criminal law. And it's only when we take fidelity to the text seriously, the text of the Constitution and the United States Code, that we can avoid unforced errors in the charging of our cases and faithfully discharge our obligations as federal prosecutors. So that's point number 1, the way we are thinking about charging and how we charge our cases matter. But the second point I'd like to make is state partners matter. I'm convinced that the only way that we will succeed in reducing violent crime in the Northern District of Texas without overstepping the proper role of the federal government is if we continue to work side by side with our partners in state law enforcement. This idea is raised most apparently in Project Safe Neighborhoods, which is a signature initiative of this administration and championed by this Attorney General to combat violent crime across the country. So after studying violent crime statistics across the Metroplex, my office, working with top-tier criminologists, have identified a particular region of Dallas that has a persistent locus of violent crime. And we have committed federal resources and prosecutorial resources to that region for a period of at least 2 years to reduce our violent crime. The only way that works is because we at the U.S. Attorney's Office are working in tandem with the District Attorney's Office, the Dallas Police Department, as well as our federal partners, the FBI, the ATF, DEA, U.S. Marshals, and many others. In every PSN case, we have an obligation to determine whether this defendant and these charges warrant federal prosecution, or whether the case is more appropriately charged at the state level. That sounds like common sense, but it requires a thoughtful approach to being an appropriately aggressive prosecutor. And importantly, and notably, it's also federalism at work in the criminal justice system. And it requires constant vigilance to mine the gap between federal and state law enforcement so that we as federal law and prosecutors are faithfully executing our responsibilities that the American people have entrusted to us. So that's point number 2. The balance between state and federal law enforcement should be and is alive and well in federal criminal justice. So now it is my privilege to introduce to you the Honorable Reed O'Connor. Judge O'Connor was appointed by President Bush as United States District Judge for the Northern District of Texas in November of 2007. Judge O'Connor graduated from the University of Houston in 1986 with a BS degree. He then graduated summa cum laude from South Texas College of Law in 1989, where he was a member of the South Texas Law Review. He began as an associate at Vinson Elkins. He then served as assistant District Attorney for the Tarrant County DA's office, and then became an Assistant United States Attorney for the Northern District of Texas. In 2003, Judge O'Connor served as counsel to the United States Senate Judiciary Committee in Washington, D.C., where he worked for then Chairman Orrin Hatch on various criminal and constitutional policy issues, and then he worked for Senator Cornyn as chief counsel to the subcommittee for immigration, border security, and citizenship. I had the good fortune of working with Judge O'Connor when he was an AUSA in our district, as well as on a few key issues that came before the Senate Judiciary Committee when he served in DC and I served in DC during the Bush administration. But here's the most important thing that you should know about Judge O'Connor. He's been married to his wife Tammy for nearly 30 years. They have 2 daughters, and I understand 2 are now successfully out of the house. So congratulations to you on that, Judge O'Connor. Please join me in welcoming Judge Reed O'Connor.
Thank you, Erin, and thank you for those kind remarks. And we are grateful for Erin's sacrifice. She's agreed to accept this appointment. We're grateful to President Trump, Senator Cornyn, and Senator Cruz for nominating her. Of course, the Senate has confirmed her. She spends a great deal of her time away from her very successful husband and her young children. So we're all very thankful to you for taking on this assignment. We have a very interesting panel and a very interesting issue to talk to you about here today. And as Erin mentioned, this is an area of discussion that doesn't fall neatly along political or ideological lines. Criminal justice reform has very strong advocates, adamant opponents, and others who are reserving judgment. For instance, former Bush-appointed United States Attorney for the District of Utah, Brett Tolman, spends a significant amount of both his professional and personal time lobbying Congress and speaking out in favor of criminal justice reform. In fact, not too long ago, he co-authored an article on this subject with one of our panelists, which we'll get to here in a minute. I asked Brett's good friend, longtime law enforcement and national security professional Ray Cavacci, who is now a Trump appointee in the Department of Homeland Security, his view on criminal justice reform and whether his view aligned with his good friend Brett Tolman. And his response to me was simply, take a look at Singapore's entry visa. On the back of Singapore's entry visa, they stamp a notice that says the death penalty is available for drug dealers. So I put him in the adamantly opposed category of criminal justice reform. Mr. Cavacci, by the way, is a former hire of Judge Jim Ho in another lifetime, and that crowd is growing. I'm a member of that crowd, and that crowd is expanding and growing all the time for good, in a good way. Now, for those of you who fall into the last category, who have reserved judgment on this issue, let me introduce our panelists today, because they are uniquely positioned to educate us on the subject of criminal justice reform and how criminal justice issues will be implemented under President Trump and Attorney General Sessions. So we will be hitting on 2 topics, I hope. One will be, in the real world, how are criminal justice issues being implemented under Attorney General Sessions' administration? And then separately as well, although the panelists may talk about both at the same time, separately, what are the public policy debates going on about this issue, and what's the likelihood that we may see something done on this issue? And our first speaker will be Mr. James Wesley Hendrix. Mr. Hendrix obtained a Bachelor of Arts degree with honors in 2000 from the University of Chicago, and then graduated with high honors in 2003 from the University of Texas School of Law. He began his legal career as a law clerk on the Fifth Circuit to Judge Patrick Higginbotham. He practiced at the law firm of Baker Botts until joining the United States Attorney's Office, where he has served as chief of the appellate division since 2012. Additionally, since 2015, he has served on the appellate chief's working group for the United States Attorney General's Advisory Committee. In addition, some of you may be contacted by the FBI to ask questions about Mr. Hendrix. That's usually not a good thing. But I think in this instance, it's a positive development. But we will reserve judgment on that as well.
Thank you, Judge.
Mr. Hendrix will speak to recent legal changes, which will immediately affect how criminal cases move forward on a day-to-day basis. He will also tell us who James DiMaia is. And we heard a mention of Mr. DiMaia in the last panel, but I think the last panel, out of respect for Mr. Hendrix and his topic here, deferred most of the talk to this panel. So we'll hear about James DiMaia and why the Supreme Court thought his case was of interest and what impact their decision will have on DOJ priorities. Hopefully, if there's time, Mr. Hendrix can tell us about some other significant cases from the last term and cases that may be on the horizon that the Department of Justice is preparing for that we should take note of. And so Mr. Hendrix will talk here in a minute. Next, let me introduce to you John Malcolm. Mr. Malcolm is Vice President for the Institute for Constitutional Government and the Director of the Meese Center for Legal and Judicial Studies for the Heritage Foundation. He is a graduate of Harvard Law School and holds a bachelor's degree in economics from Columbia College. He has clerked at both the district and circuit level and has worked in private practice. Pertinent to his experience that I think qualifies him to not testify, but speak today, is some street cred. Because he served for a number of years as an assistant United States attorney in Atlanta, handling a variety of cases, including a high-profile prosecution that involved the assassination of a circuit judge and the chapter president of the NAACP. Later, he served as a deputy assistant attorney general in the criminal division. He has held leadership positions in the religious freedom community and is chairman of the criminal law practice group for the Federalist Society. He is an accomplished author, public policy speaker, and leading thinker in the criminal justice reform discussion. I also want to introduce at this time Mr. Mark Levin. I want to introduce both of them at this time because both are nationally known and respected experts on criminal justice reform and will touch on some of the same topics. Mr. Levin is the Vice President of Criminal Justice at the Texas Public Policy Foundation. He is a graduate with honors from the University of Texas in Plan 2 Honors and Government. He has a JD with honors from the University of Texas School of Law and clerked on the Fifth Circuit for Judge Garwood. He is an attorney, an accomplished author, and leader on public policy issues, particularly on criminal justice reform. He has been called upon by a number of policymakers and thinkers to share his expertise. And since we are in Texas, I think it is important to note his influence on former Texas Governor Rick Perry, who has lauded him on his leadership on this issue. Finally, many of you work in Washington or pay attention to what's going on in Washington, so I thought it important to note that the Washington, D.C.-based magazine Politico named him to their Politico 50, the magazine's annual, quote, list of thinkers, doers, and dreamers who really matter in this age of gridlock and dysfunction, close quote. Mr. Malcolm and Mr. Levin will speak to us on what they see as the pros and cons of the change in philosophy from the previous Justice Department to this one, as well as hopefully updating us on congressional efforts to pass criminal justice reform legislation, and perhaps they might be able to comment on how General Sessions' legislative reform views line up or do not line up with those of White House policymakers on this issue. And finally, I hope they have time, because I think you will appreciate it, to discuss how and why their research has influenced policymakers' beliefs on these very important issues. And then finally, we will hear from Steve Fahey. Mr. Fahey is a graduate of the University of Chicago, where he obtained a major in history. He later obtained his law degree from the University of Texas. He served as a law clerk here in the Northern District of Texas for Judge Mahon, entered private practice at Jenner & Block, and later joined the United States Attorney's Office, where he has served the past 15 years. In the United States Attorney's Office, he has held a variety of positions, in both criminal and civil divisions under various U.S. attorneys. He was the office's previous civil chief, and now under U.S. Attorney Erin Cox, he is the criminal chief. So some of those priorities that Ms. Cox mentioned, Mr. Fahey will be in charge of implementing and make sure the office implements them in the way that she envisions them. I hope that Mr. Fahey will have some time to point out some of the differences between the priorities between the two administrations, the change from the previous one to this one, since he's been in many positions under both, and how those decisions will affect the day-to-day prosecutions, and to the extent he has time and can, or is authorized to talk about it, comment on DOJ's views on criminal justice reform as a policy matter. And so with that said, let me turn the floor over to Mr. Hendrix for his presentation.
Thank you, Judge. Thank you for that kind introduction. Thank you also to the Federalist Society for inviting me to be here today. It's my honor. It's my honor also to be with a former classmate and my friends on this panel. So I'm going to focus my time today on two fairly recent Supreme Court cases, DiMaia and Johnson, because they directly impact one of the Attorney General's top priorities, and that's the reduction of violent crime. These decisions also provide a window into the justices' minds of how they approach issues like this. And then finally, they demonstrate really what's at stake when it comes to policies and statutes that do try to identify and neutralize violent crime. So we'll start with DiMaia, and one question was, well, who is he? So James DiMaia was a lawful permanent resident of the United States. So all that means he's a non-citizen, but he was present lawfully. However, he then committed 2 felony offenses in California, residential burglary, and the United States tried to remove him in civil immigration removal proceedings. And they tried to remove him as an aggravated felon. And if you're categorized as an aggravated felon, you're essentially guaranteed to be removed from the United States. So the question in the case became, does California residential burglary qualify as an aggravated felony? That depends, of course, on the definition of aggravated felony. For purposes of immigration law, there's a really long list of many things that can qualify, enumerating specific offenses. But for our purposes, also included in that list is the general crime of violence definition that's included in Title 18, the Criminal Code of the United States. So if something is a crime of violence for purposes of Title 18, it's also an aggravated felony for immigration purposes. And part of that definition says it's a crime of violence if it's a felony that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. Now, in deciding that, all right, does this state burglary offense meet that definition? Courts, surprisingly to some who don't practice in this area, they don't look, and they cannot look under the case law currently, at what actually happened. So even if the documents in that case show that he went in by force and encountered the homeowner and beat the homeowner up, for example, doesn't matter. You can't look at that. You look categorically. It's called the categorical approach. And you just ask, does the general kind of ordinary case of burglary meet this definition? The Immigration Court and the Board of Immigration Appeals said, yes, it does. He's an aggravated felon. He is removable. The Ninth Circuit reversed. And they didn't reverse based on the specific case. They held that the definition of crime of violence, this piece of it anyway that I mentioned, was unconstitutionally vague. Big deal, because not only is it rendering invalid a key definition for immigration purposes, it's also rendering invalid the default crime of violence definition for all criminal offenses. So, as you can imagine, the United States petitioned for cert, and the Supreme Court was interested in the case. The Supreme Court affirmed. In a decision 5-4, Justice Kagan wrote for the majority, joined by Ginsburg, Breyer, Sotomayor, and interestingly, Gorsuch. And driving the analysis of the majority was this case called Johnson. Johnson came out in 2015, and to understand DiMaia, you have to understand Johnson. Johnson involved the Armed Career Criminal Act. That act provides that if a felon who is caught with a gun which is a federal offense, has 3 or more prior violent felony convictions or serious drug offense convictions. So you've committed 3 violent felonies, 3 serious drug offenses, and then you get out, you're caught with a gun, your sentence starts at 15 years and can go up to life. Whereas normally a gun offense in the federal system is going to be 0 to 10. So it's a significant increase in the potential sentence. Because Congress said, look, if you've had 3 chances, and these are either violent or serious drug offenses, and you're out there with a gun, you clearly haven't learned your lesson, you're starting at 15 years. In Johnson, the Supreme Court held that a portion of the violent felony definition that's similar to the crime of violence definition in DiMaia was unconstitutionally vague. And they reached that holding because the categorical approach requires judges to imagine what is the ordinary case and then ask, does that ordinary case rise to a sufficient level of risk? And Johnson majority just said, look, that's unworkable, it's unconstitutionally vague. And that drove the bus in DiMaia. They reached the same conclusion in DiMaia for essentially the same reasons. Justice Gorsuch concurred, and he focused especially on the vagueness doctrine as a way of forcing Congress to speak more clearly and to keep courts from speaking for it, a laudable goal. This is, for Justice Gorsuch, both a due process concern and a separation of powers concern, but he hinted that maybe the categorical approach, which is really the problem here, maybe it just doesn't need to apply at all. Parties hadn't really addressed that, so he didn't reach it. Roberts dissented, joined by Thomas, Alito, and Kennedy, and he said, well, hold on. We've applied this statute in the past, and we've applied it unanimously. Unlike the Armed Career Criminal Act in Johnson, where we've had trouble figuring out how this works, we haven't had trouble figuring out how this works, so I'm surprised to hear that this is unconstitutionally vague. And then Roberts focused almost exclusively from that point on the text and the textual differences in the statute. Thomas, joined by Alito and Kennedy, focused his dissent on his doubt that striking a law as unconstitutionally vague could be consistent with the original meaning of the Due Process Clause. He's just generally skeptical of that idea as a whole. Instead, he would use principles like the rule of lenity if a statute is unworkable, but not the Due Process Clause and vagueness. And then finally, he also focused on the idea of judicial constraint and constitutional avoidance. There is a way around this problem in Justice Thomas's mind, and then that's just scuttling the categorical approach. We shouldn't shut our eyes to reality of what this person did. It's not necessary, and if we get rid of that, all of this falls away. So that's what we have. We have 2 Supreme Court cases who have invalidated key provisions that federal prosecutors use to combat violent crime. So how does this impact our priorities? In a very big way, Because both statutes, one, going forward, they impact our work on a daily basis. But the Supreme Court also made these decisions retroactive. So if you are a federal prisoner and you received an ACCA sentence based on this now defunct definition, you can challenge your sentence and either get it reduced or be released. And the reason that matters is armed career criminals, Congress determined that they are uniquely dangerous. Again, if you're an armed career criminal, you've already committed 3 or more violent felonies in some cases. You're then caught with a gun. And we have data from the Sentencing Commission that indicates that 7 of 10 career offenders reoffend after they get out, which is up at the highest end of recidivism. Sentencing Commission data also shows that federal gun offenders are some of the most likely to reoffend. Well, ACCA offenders are both. They're both career offenders and they're gun offenders. So high rate of recidivism. And we now know, because we're 3 years removed from Johnson, of what this means. What is the fallout? We're starting to kind of see the real world consequences of this. And they're dramatic. 1,400, actually a little bit more than 1,400 prisoners have been released, so not including the ones that have had their sentences reduced. But the 1,400 armed career criminals have been released because of Johnson, and of those, over 600 have already reoffended. And they're significant crimes. There so far been 10 murders, Of these people who were released, 14 kidnappings, 11 sexual assaults, 37 robberies. I could go on, but I won't. I mean, you get the idea here. And sadly, it's not a problem that's limited to any part of the country. It has come home to roost here as well. In the Northern District of Texas, recently, a district court judge who was applying binding Fifth Circuit precedent concluded that Texas murder is not a violent felony. And again, applying Fifth Circuit precedent, maybe the law will change, maybe it won't, but as it stands currently, in this world of the categorical approach, where you don't look at the actual conduct, that person was released. Other Johnson releasees have committed aggravated assault and burglary, and others. So in our view, and in the Attorney General's view, the stakes are high here. The loss of 16B is similar. That impacts criminal immigration. It's also retroactive. And most notably, the definition that was invalidated in DiMaia, there is identical language in another piece of Title 18, 924C. So for those that are unfamiliar with the criminal justice world, very common statute that provides that if you use or possess a gun in furtherance of a crime of violence, which in Congress's view makes you extra dangerous, you get extra time. And multiple circuit courts have held that that is likewise, that piece of the definition anyway, is likewise unconstitutionally vague. And these are tools that are used by our prosecutors all the time, and they're falling because of Johnson and DiMaia. Now, the fight's not over. There are multiple en banc courts that are considering this. The government has lost the issue in the 10th Circuit. Yesterday, in fact, the 5th Circuit, in a case called Davis, out of our district, held that this piece of 924C that's identical to DiMaia was unconstitutionally vague. The adverse decision process is underway there. The government has already filed a petition for rehearing en banc in D.C., and the 4th and the 11th Circuit, sua sponte, ordered en banc proceedings. So the courts continue to grapple with this, but I think you get the picture, right? The stakes are high, and this area is particularly focused just on what the Attorney General and the Department view as the most dangerous. They are recidivists who are committing violence, who have guns. Other Supreme Court decisions, I don't know if I'm short on time, Judge, but Carpenter, I think, was mentioned earlier. That was an enormous decision from the Supreme Court. The court held that a warrant is required to get historic cell site location information. There is a statute that previously addressed this that required agents and prosecutors to go to a judge and apply for essentially a subpoena to go get this from your cell phone provider under the third-party doctrine. You've shared this information with a third party. It's no longer essentially your private data. And the court said, that's not enough. Yes, there's a statute. Yes, you went and got a subpoena, but you need to get a warrant. You need to show probable cause. So that's what we're going to do going forward. Next term, a couple of cases to keep an eye on. One is called Stitt. It is related to this categorical approach. It's kind of another round in this fight, and the court continues to grapple with it. And the question there is whether Arkansas burglary can qualify as generic burglary, and that might seem like a small, very tiny case that doesn't apply to a lot of people, but it's exceptionally significant because these predicate offenses are ways that in the appropriately aggressive charging that my U.S. attorney mentioned can identify kind of the worst of the worst and protect the community by neutralizing them when appropriate and securing longer sentences. The government has asked the Supreme Court to really focus on the text of the Armed Career Criminal Act and what it meant at the time of passage. Because at the time of passage, in our view, burglary had to include what's at issue in Stitt. Similarly, there's another case called Stokeling, which asks whether Florida robbery can constitute a violent felony. So, I mean, these are large issues. They're making their way to the court, and the impact is significant. Because if the answer is no, then you're going to, there'll be defendants before judges that have previously been convicted of murder and robbery and burglary, and the court is hands will be tied and they'll say, I'm sorry, that's not a violent felony. And the sentences will reflect that. The final thing that the judge asked me to address was, are there potential legislative solutions to this? And there are. There is a Johnson fix, restoring the Armed Career Criminal Act that has been introduced in the Senate by Senators Cotton and Hatch, and it would essentially scuttle the categorical approach. Just, this is not working, we've lost our way, let's get rid of violent felony and serious drug offense, and go through this game of shoehorning state crimes into these definitions, and let's just say that any crime punishable of 10 years or more qualifies. It lowers, notably, the cap. It keeps the 15-year minimum, but it lowers the cap from life to 30. This is, the department hasn't taken an official position on any of these, but the Attorney General has applauded the effort to seek some fix. And if you'd like to learn more about this, my U.S. Attorney published an editorial addressing these very things in the Dallas Morning News recently. There is a DiMaia fix that passed the House, as a matter of fact, yesterday, the Community Safety and Security Act, and it seeks to remedy the problem in DiMaia by removing this unconstitutionally vague definition and just providing a really long list of crimes that would qualify. And then finally, for 924C, because it's such a common statute, nothing has been introduced, but the Senate Judiciary Committee has expressed interest in fixing it, and we anticipate that it will be a similar fix to the DiMaia fix. Instead of a general definition that is subject to a vagueness challenge, provide a really long list, or however long the Senate Judiciary Committee wants it. It's easier in the 924C realm because only federal crimes can qualify as the predicate for 924C, so it's an easier nut to crack, I guess. So that's what we slate front.
Thank you, Mr. Malcolm.
Well, I guess I'll start by saying one thing. First of all, it's a privilege to be on this panel. I'm going to push back. I'm going to get to sentencing reform and criminal justice reform in a little bit, but I want to push back to something that Erin Cox said, which she started out by saying, well, there are people who are opposed to criminal justice reform, and then there are other people who think that the criminal justice system is broken and in need of reform. And I want to come down squarely and say, I don't think the criminal justice system is broken. I do not think that it is systemically racist. I do not consider drug offenses. You hear a number of people who are in favor of reform saying nonviolent drug offenses. I'll be the first to admit that most drug offenses, certainly at the federal level, involve gang involvement, involves potential weapons. There's the ever-present risk of overdose, so I think violence is inherent in drug offenses. You'll hear a lot of reformers talk about mass incarceration. I never talk about mass incarceration. I don't know whether we incarcerate too many people or too few people. I am in favor of incarcerating the right people for the right length of time, no more, no less. But I am in favor of certain reforms within the criminal justice system, because I think that in a number of instances, the pendulum has swung too far in terms of some of the sentences that are imposed. And also, I think that there are various reforms in terms of the First Step Act that we can do that will make it less likely that when people are released from prison that they will recidivate, to drive down some of the high recidivism rates that Wes just talked about. I was first asked, before getting to anything having to do with criminal justice reform, to talk about some of the changes that the Sessions Justice Department has made over the Holder-Lynch Justice Department, and there have been several significant changes, some dealing with criminal law, some not dealing with criminal law. I'll tick off a few of them. So Erin made reference to the fact that there is a renewed emphasis, not only here in Texas, but elsewhere, on immigration offenses and violent crime cases, firearms-related offenses. I read the other day, I think that firearms prosecutions are up by close to 23%. Year on year, this year from the previous year. There was another change that General Sessions made, somewhat controversial. Either you like it or you don't like it. And this is a change that has happened repeatedly now between Democratic administrations and Republican administrations. So Democratic administrations have come in and have given AUSAs substantial leeway in terms of making a decision whether to charge a mandatory minimum offense or not. And Republicans come back into power. We did it with General Ashcroft, doing it now with General Sessions, and says no, that AUSAs have to charge the highest readily provable offense unless they get very, very high level clearance to avoid a mandatory minimum charge. Other very significant things that are not so much related to criminal law. General Sessions has now, as a matter of policy, there's pending legislation to make this the law of the land, has ended the practice of prosecutors entering into either deferred prosecution agreements or non-prosecution agreements that require the target who enters into that agreement to make payments to non-victim third parties. There is, as I say, legislation called the Stop Settlement Slush Fund that's pending before Congress that would make this law. This is very significant. I mean, once you enter into these agreements and get these payments, it is now taxpayer dollars, and you ended up having U.S. attorneys agreeing to give money to private interest groups who are non-victims, who may have something to say about the area covered by the agreement, not always, without going through the appropriations process. I think that this move is great, and it will rein in what is known as the sue and settlement phenomenon, which I think is very important. Another change before she departed for the greener pastures of Walmart, Rachel Brand, the Associate Attorney General, issued what is now referred to as the Brand Memo, and it prevents Department of Justice lawyers from relying on agency guidance documents in court and saying that those guidance documents should somehow be entitled to Chevron deference in lawsuits involving the government and private parties. The administration is obviously revisiting the issue in terms of investigations of police officers. So under the Obama administration, frequently when there was a white police officer who would shoot a black citizen, armed or unarmed, frequently the Holder and Lynch Justice Department would race in and start, Civil Rights Division would race in and start conducting pattern and practice investigations that led to settlements that really rein the ability of police officers to do what they do. And the Sessions Justice Department has said, we're going to not do that. We're going to examine these cases and have a more cooperative relationship with police officers. And then also, they are also taking a different look, the Justice Department, on racial preferences. So there's a big case going on now by a private interest group that has challenged the admissions practices at Harvard University and at the University of North Carolina at Chapel Hill. The case is scheduled to go to trial in mid-October, and the Department of Justice has just entered a statement of interest in the Harvard case. I'm pretty sure that neither the Holder nor Lynch Justice Departments would have done that. They come in on the side of the challengers of Harvard's racial preference practices. So I'm sure that there are other changes that the department has made, but those are fairly significant changes. And I assume we'll talk about criminal justice reform measures later, or?
Can you go ahead and address that now?
Sure. So there are various criminal justice reform measures that are being currently debated in Congress. I'll put them into two categories. One is called prison reform, which is the First Step Act. And then there are 4 sentencing provisions that are in play. The First Step Act has passed the House of Representatives with overwhelming bipartisan support. I forget, it was a 300-something to 40-something. I mean, it was a large vote, and is in the Senate Judiciary Committee. The guts of the First Step Act, so there are a couple of minor provisions. It calls for changing the compassionate release program, reforms to the compassionate release program that the department has. It's a little provision, I don't know why this was necessary, that if a pregnant inmate is delivering, that she cannot be shackled which is actually the current practice that goes on now for female inmates that are giving birth. But the guts of the First Step Act, prison reform, is designed to, as I say, reduce recidivism risks. And what it does is it looks at each inmate, and they go through a validated risk needs assessment to find out what is the risk of this offender recidivating. Is it minimum, low, medium, or high? And then it says, what are their needs? Was there something that contributed, that had a crimogenic effect, that contributed to this person committing the crime? Is it lack of job skills? Is it lack of education? Do they have a substance abuse problem? Is there a mental health issue going on? And it tries to pair each inmate. It's not mandatory, it's voluntary. It pairs each inmate with programs in prison to meet those needs. And it provides some modest, although some will disagree with whether they're modest or not, incentives to people to get them to avail themselves of these programs and for successful completion. And the incentive varies depending on whether you're a minimum, low, medium, or high risk offender. And there are a whole slew of offenses, including virtually every violent crime, child abuse crimes, even drug crimes, if the government establishes that the drug crime resulted in death or substantial bodily injury. But if you don't fit within any of these exclusions, you can take these programs, and you don't get time off your sentence, even if you're medium and high risk offenders don't get any time off their sentence. They get other things like extra prison yard time or email privileges or phone privileges. And the time varies on whether you're a minimum or low risk offender. And you don't get time off your sentence, but you do get a change of conditions. So you can go to home detention or community supervision for the period of time for the credits that you earn based on the programs that you take. And the purpose, again, for doing so is to say, look, 95% of the people who are in prison now, whether you like it or not, are at some point going to be back in our communities. And if you don't address the issues that led them to commit crime in the first place, it is highly, highly likely that they are going to recidivate. So is there something that we can do, while we actually have physical control over these people, to say, do something that will improve your life, make it far more likely that upon release you are going to be a law-abiding citizen. And oh, by the way, it also makes it a lot less likely that you are going to recidivate and therefore will enhance public safety. That's the guts of the First Step Act. And then there are these 4 sentencing provisions. I'll tick them off quickly. One of them is an expansion. Exactly how much of an expansion is unknown because the text hasn't been provided yet. A modest expansion to what is known as the safety valve, which enables somebody with a minimal criminal record to avoid a mandatory minimum sentence. The other way to avoid a mandatory minimum sentence is by providing substantial assistance. But these are people who don't have the kind of information that a prosecutor can use. They have to tell everything to the government, but it will not be enough so that they can do something with that information to give them meriting a substantial assistance departure. But if they have a minimal record, and they had a minor role in the offense, they can get out under the safety valve. Second one would make the Fair Sentencing Act retroactive. The Fair Sentencing Act was the law that reduced the crack cocaine, powder cocaine disparity. It used to be 100 to 1, and now it's 18 to 1. So you had some people who were, and it made it prospective only. So you have some people who were sentenced to mandatory minimum offenses before the Fair Sentencing Act came into effect, where Congress and the President made the determination that these sentences were unconscionably large, and it would enable these people not to automatically get their sentences reduced, but to at least petition a court that would give them that opportunity. The third thing is that there are enhancements for drug offenses if it's under Section 851, sentencing enhancement. If you have a prior drug offense and you commit another offense and the government gives notice, you can get a 20-year sentence if this is tacked onto the whatever the underlying guideline offense would have been. And then if it's a third offense, you would get a automatic life imprisonment. And it doesn't matter how old the sentence was, the prior drug offense was. It doesn't matter whether it was simple possession or not. But if it was a drug offense, you can get these things tacked on. It would pare back those numbers, I think, from 20 down to 15 and from life down to 25 years. And the final one is, I think everybody basically agrees with this for the most part, which is there's this anomalous thing in the law, and references 924C, where it says if you commit a drug offense and you use, carry, or brandish a firearm, you get whatever sentence you're going to get for the underlying drug offense, plus a mandatory minimum sentence tacked on top of that. And the way most people believe the law was intended to be written. Oh, and then if you commit a second offense, you get everything for the drug offense, plus the first mandatory minimum, and a bigger mandatory minimum. And same thing with the third offense. And everyone believes that what Congress intended was, if you get convicted and you carried a gun, you get the drug offense, you get the mandatory minimum. Once you're out, you do it again, drug offense, bigger mandatory minimum. Once you're out, do it again, underlying drug offense, huge mandatory minimum. But the way the law is written, and the Supreme Court has said this, it doesn't have to be separate convictions. So if I am a drug dealer and I go out on 3 days and deal with a government informant, an undercover informant, and on each of those occasions I carry a firearm, even if I never pull it out, but it's known that I carry a firearm, I can be charged with 3 separate 924C charges, which means I get even if it's the first time I've ever been convicted of anything, I get all of the time for the underlying drug offenses, I get the first mandatory minimum for day 1, I get the second much larger mandatory minimum tacked on top of that for day 2, and I get the huge mandatory minimum tacked on top of all of that for day 3. So there's this famous case of Weldon Angelos, who sentence got commuted by President Obama, but he had never been convicted of a drug offense before. He engaged in a series of transactions with an undercover guy. I think it was, in fact, 3 times. And even though he had never been convicted of anything before, he got all of the sentence for the underlying drug offense plus 55 years tacked on top of that. And so this fix would make it clear that no, it's first conviction, then you're out, second conviction, then you're out, third conviction, and not sequential drug deals. I think that covers it.
Thank you, Mr. Levin.
Well, thank you, and it's great to be here, especially with my former colleague, Vikrant Reddy, who helped me start our Right on Crime initiative, and of course our current General Counsel, Rob Henneke, and many old friends from law school at UT back in many years ago when I headed the Federalist Society there. But before I get into a bunch of other stuff, and I strongly align myself with virtually everything that's been said already, and I did want to add on Weldon Angelos, he was selling marijuana, which I think is also a notable part, but 55 years was an extreme sentence, I think, by any stretch of the imagination. But I really believe that it's important to, as I think John said, emphasize, certainly both of us are not about an arbitrary reduction in incarceration. I know you sometimes hear cut 50, but rather making sure, as he said, we have the people in prison we're afraid of, not those we're mad at, and for an appropriate amount of time. And I think it's important to note the federal criminal justice efforts have really stemmed from the success in the states, and it's been even more pronounced in red states like Texas, and with conservative governors, whether it's Governor Nathan Deal in Georgia, Nikki Haley when she was governor of South Carolina, and of course our own former Governor Perry and our current Governor Greg Abbott. But they have really said, let's look at making sure that we don't incarcerate more people than necessary, and that we get the best public safety results for every dollar we spend. And so here in Texas, since we started down the road of criminal justice reform about a decade ago, our crime rate's down over 30%. and our incarceration rate is down over 20%. We've closed 8 prisons. We saved about $3 billion versus had we built all the prisons that were projected to have been built. So it's a strong record. And now I do acknowledge, and I think this is important when we hear from some excellent U.S. attorneys and other federal officials, there is a difference still between state systems and the federal system. And ideally, the federal system ought to be taking the most serious offenders, those involved in international gang activity, drug kingpins, and so forth. I think over the years, what we've seen, though, is more lower-level street corner drug dealers go into the federal system, and I think that's created some of the issues with the mandatory minimums. But, you know, in looking at it, I think that we've been asked to kind of assess the current Attorney General, and I think that, and some of the changes that have been made. And I think, first of all, it's important to note the federal prison population has continued to decline under this president, and obviously there could be a lot of reasons for that. I know at least at the beginning of the administration there were fewer federal border crossings, fewer cases associated with that, since evidently some individuals were deciding not to come. So that affects, there's a lot of different drivers. And then you did have the clemencies at the end of the Obama administration. Some of you may remember about a month ago, President Trump commuted the sentence of Alice Marie Johnson, a woman who was serving life in prison, a low-level drug offender. And I think that we need to re-energize the clemency process. I think it's kind of odd that it's housed at the Department of Justice in some ways, because here in Texas we have the Board of Parole, which is not part of district attorneys. So we don't have the prosecutors deciding who should be suggested for clemency. So I think it's helpful to look at that. Now, one of the other things I think very positive under the current Attorney General has been a tremendous support for problem-solving courts, drug courts, veterans courts, mental health courts. They're at record levels of funding and level participants, and the outcomes are outstanding by and large in terms of reducing recidivism through kind of this treatment-based approach where the court provides ongoing oversight instead of just passing someone on to another system. The other thing that's really been important is a focus on reentry. I met with, starting almost a year ago, with Jared Kushner and others at the White House to look at how could we reduce recidivism? And one thing that really stood out was that the Attorney General, that virtually everyone in the administration felt that focusing on how we can prepare someone to reenter society and then having a unified effort with what they would experience as soon as they were discharged. Now, we still have states in this country where people are released from prison without a photo ID. We sought to remedy that in Texas, where now you at least get all the documents needed to get a photo ID as soon as you're out of prison, and we have one mobile unit that issues photo IDs. Another example, here in Texas, we found people that had people who were trained to be barbers in prison couldn't get a cosmetology license. Even the Obama administration recognized occupational licensing has gone too far when 1/3 of American workers have to have a license from the government. So we have these barriers that people face when they come out of prison, known as collateral consequences, or even with a criminal record. So those are some of the things that we sought to focus on. And so the president signed an order, executive order, establishing the Federal Interagency Reentry Council, where every agency has come together and said, what can we do to remove some of these barriers? And I think some of the steps we're seeing are very encouraging. For example, the Department of Labor, some of the work they're doing. And by the way, of course, with this tightening labor market, there's many more businesses stepping up to the plate saying we're willing to hire people with a criminal record, which is about 1/3 of American adults. So it's a large number of people. Now, I think we can all agree focusing federal prosecution resources on the most violent and dangerous criminals makes sense. And I think what we would add to that is to say that, you know, prosecution is just one tool in the toolbox. And you look in some of these communities where high levels of gang violence are being experienced, we have to ask ourselves, how can we prevent that? How can we get, it's usually young men, to stand down and get out of the gang and get into something positive? And so there's some great models in terms of Operation Ceasefire, for example, where these young gang members are identified, they're brought into a community meeting, you have someone from the U.S. Attorney's Office, you have ministers, you have grandmas, you have people ready to provide job opportunities all in this meeting and say, look, we have some goods on you. In some cases they probably do, in some cases they don't, but we have videos of some of these people. It may not be enough to bring charges, but if you leave, you take these positive opportunities, we've got a lot of opportunities for you, but if you continue doing what you're doing, you're going to have the full weight of federal law enforcement. And those efforts have had great success in reducing gang violence. Now, one of the critical things, I think, in the federal, state, and local partnerships is, of course, being cognizant of federalism, as was mentioned earlier, and making sure that we do prioritize cases for federal prosecution involving crimes across state lines, international cases. Not every case that could get a higher sentence under federal law should necessarily be a federal case. One of the other issues that, of course, has come up during Attorney General Sessions' administration is the issue of the drug charging memo, where the Holder memo was withdrawn, and the current memo basically says that, by the way, for those of you who aren't familiar with it, the Holder memo said that, that in lower-level drug cases, prosecutors should not specify the weight in the drug charges so as not to trigger mandatory minimums. The new memo basically says that every case should be charged to the fullest extent to get the maximum sentence that could be provable, and that if the line prosecutor wants an exception to that, they have to get permission from their U.S. attorney or Maine DOJ. And I think that, you know, when we're at the Capitol here in Texas talking to Texas prosecutors, the biggest thing they say is prosecutorial discretion. So I really do think that's important. And it's unclear whether this change is really having that much of an impact. When you look at the cases that would have got downward departures anyway for substantial assistance or the safety valve, that maybe only 400 or 500 cases a year are actually affected one way or another by this. So, but I do think it's important to remember that prosecutors don't have an obligation to charge every person with every crime that they possibly could, which also brings to mind the issue of overcriminalization, which is near and dear to many of our hearts. I serve with Judge Busby on a state commission that's looking at the over 1,500 offenses here in Texas outside the penal code, including 11 felonies for harvesting oysters, various violations in the course of that. At the federal level, as many of you know, over 4,500 offenses were counted by the General Accounting Office before they gave up counting. So this is an area that where we just have seen the growth of criminal law run parallel to the broader growth in government, and particularly the administrative state. And what we have in many cases is it's been improperly delegated to government agencies to create new crimes themselves. An example here in Texas is we have a law that says it's a Class A misdemeanor up to a year in jail for violating any regulation, any occupational agency regulation. So every time these agencies, their boards meet, they're effectively able to create new crimes. Dick Thornburg estimated there may be as many as 300,000 federal crimes through regulation, which is outrageous. And one of the provisions, by the way, in some of the current federal forms require every agency to post on its website every regulatory crime that they have. Let me just touch on a few other things before I wrap up. One of them is there's a lot of litigation now concerning bail, and here in Dallas County, also in Harris County, in our federal courts. And I think that it's important to recognize that there are serious issues involving a lack of due process in terms of the pretrial system in this country. And so the reality is, in most places, what happens pretrial is essentially most of the ball game in a lot of cases, because people end up pleading to time served. And so what happened, for example, in Harris County was a number of people charged with misdemeanors, and the federal case there solely concerned misdemeanors, but 40% of them ended up pleading to time served. They were not released solely because they couldn't afford bail, in many cases $500 or $1,000, and they ended up pleading to time served. Actually, hundreds of them were cases involving less than a gram of drugs, and then a year later, due to some problems in the crime lab, it was determined the substance wasn't even illegal drugs, but they had already done their time. And so, and then the lack of due process, not having an attorney. In Dallas, these bail hearings are now 15 seconds in some cases. This has been, came out earlier this week. So I think we absolutely have to insist that there be due process. I think it's wrong to detain people solely because they can't afford a certain amount of money. Fortunately, there's new tools in terms of actuarial risk assessments that do a good job of informing judicial discretion and who's a risk to public safety, who's a risk of failing to appear. Some groups on the left, unfortunately, have now started attacking these risk assessments as being racist, but they're not a substitute. Now, nobody is saying algorithms should substitute for the judge's discretion, but these, many of these assessments look at things like previous failures to appear, previous violent crimes, and so forth. And so I think they're very valuable. Our Texas Supreme Court has just promulgated an electronic risk assessment that's now being piloted in Dallas, that's been based on research that's been validated to accurately predict whether someone will fail to appear and whether they will commit an offense or be rearrested for an offense, particularly a serious one, prior to their trial. So our view is we should have a system based on risk and public safety rather than ability to pay in terms of pretrial decisions. And I think that will, frankly, save our counties a lot of money in federal litigation. Harris County, unfortunately, has incurred over $7 million in legal fees involving pretrial detention, not to mention the huge cost to taxpayers in keeping people in jail who aren't a risk to public safety. So the federal system is actually quite a bit better in that regard, and I think it's something that many states can learn from. I will finally just touch on some of the issues that John mentioned regarding the bills pending in Congress. There are some additional bills as well, including clean slate, where people could, certain low-level drug offenders could eventually get their federal records sealed. And then there's also a bill to end juvenile life without parole at the federal level. So those who commit crimes 17 or younger at the time of the offense would have a review after 20 years. Texas has done a similar thing, as have many other states, partly to come into compliance with Supreme Court precedent, but I would certainly think that those are valuable pieces of legislation as well. So I'm encouraged. I think that, as was alluded to earlier, there's a real growing consensus that certain reforms make sense. I think criminal justice reform is a very broad phrase, so there also, we do want to make sure that I would say we're both tough and smart. So it's not a matter of whether we're tough on crime, but doing so in a smart way. And, you know, finally, I would say if you talk to many individuals who have gone to a drug court and gotten sober and things like that, they would tell you that was tougher than sitting in a jail cell.
Thank you. You know you have a top-level expert when you have a time limit imposed and they want to get all of their topics in. There's not a court reporter in this state that would have been able to get all of that down, but I hope you all were able to do it. With that said, Mr. Fahey, I'll turn the floor over to you.
Thank you, Judge. As I was coming in, like you this morning, broad jumping over streaming rivers of water on the street, I thought, what is a better fit for our gloomy, rainy weather than discussion of crime and punishment? But first, good news. The reduction in violent crime in the United States in the last quarter century, I think, is the major public policy success story, possibly of the last couple of generations, along with, of course, the reform of welfare in the 1990s. Innovations in policing and tough anti-crime legislation that passed with huge bipartisan majorities in the 80s and the 1990s, including increased incarceration of offenders, mandatory minimum laws, and tightened parole, have played a key role in reducing violent crime in the United States. And that violent crime rate skyrocketed 350% between 1960 and 1990. But from 1991 through 2014, the violent crime rate in this country was cut in half. Murders down by half. Robberies 2/3. Rape fell by 1/3. The number of aggregated assaults fell by half. But in recent years, I think perhaps due in part to complacency brought about because of safer cities and that tumbling crime rate, I think the prevailing consensus in the United States is that we're in the throes of a mass incarceration crisis. That our prisons are being overcrowded prisons, are continued to be indiscriminately filled up with so-called low-level, nonviolent drug offenders. As then Attorney General Eric Holder sort of summarized this view when he told the ABA in an August 2013 speech, "Too many Americans go to too many prisons for far too long and for no truly good law enforcement reason." The overwhelming, and I appreciate John's comment that as a conservative, he doesn't believe this, but I do think the overwhelming consensus, at least in the media and in Washington, seems to be that our criminal justice program is broken and that is in desperate need of reform. And I think, as John talked about, it seems likely that in the near term, Congress is going to consider legislation that, at least on the table, will be considerations, provisions that would scale back mandatory minimum laws and other provisions that would reduce the time that federal inmates serve in prison. But while the reform movement has focused on ways to reduce the number of people in federal prison and the amount of time they serve, something's been happening since 2014. And that is the violent crime rate has started to a worrisome trend upward. We have now experienced the two largest single-year increases in the national violent crime rate in a quarter of a century. The murder rate jumped by a combined 20% in 2015 and 2016. And as you all know from the headlines, our country is fighting an increasingly deadly opioid epidemic with a record 72,000 overdose deaths last year, which was up 7% from 2016. Perhaps not coincidentally, the average sentence length for federal drug traffickers sentenced in 2016 was about 20% lower than in a same defendant sentenced in 2009. And the number of federal inmates, as was touched upon, is at the lowest level since 2004. It's declined 16% since 2013, when the Smart on Crime initiative was begun under the second term of the Obama administration. So as several of the speakers have talked about, and I won't get into, given lunches about here with Justice Thomas, Attorney General Sessions came into office with this uptick in violent crime, and he quickly signaled the break from the Smart on Crime program that Attorney Generals Holder and Lynch had been emphasizing during the second term of President Obama. On his first 60 days on the job, the Attorney General issued those two memoranda that have been talked about, prioritizing the fight against violent crime and the enforcement of criminal immigration laws. And most important probably to us at the local level, he bolstered this emphasis on violent crime and immigration by adding 300 new AUSA positions nationwide, which was the largest expansion of the Justice Department in decades. Here in the Northern District of Texas, for example, we were in a group of districts, a small group of districts that received the second largest allocation of new violent crime prosecutors. We have 6 new AUSAs on hand, which is probably a 7 or 8% increase in our staffing to handle violent crime and immigration prosecutions. And as U.S. Attorney Nealy Cox talked about, we have revitalized the Project Safe Neighborhoods program, which is the centerpiece of Attorney General Sessions' fight against violent crime. And PSN is a partnership between the federal, state, and local law enforcement and community leaders, and using cutting-edge technology to locate and target the most violent offenders in a particular geographic area. And we have kicked off that emphasis in Dallas in a particular neighborhood. And of course, as John and Mark have mentioned already, the Attorney General's memo rescinding the Holder charging policy and directing prosecutors to charge the most serious, readily provable offense is the last notable change I would talk about. And since it's already been talked about, I would emphasize that in explaining the policy change, something very important that Attorney General Sessions said is that this was a return to enforcing the criminal laws as written and fully utilizing the tools given to Congress, to us, to fight drug trafficking. I think both of those are worthy goals for the rule of law, in my opinion. So I believe at the end of this month, the FBI is scheduled to release its comprehensive national crime statistics for 2017. The numbers will tell us if the violent crime rate, which has been going up the past few years, continued its recent uptick, or perhaps has resumed the overall decline we've seen because of these successful policies in the past 3 decades. As we continue and Congress starts to debate that legislation regarding reform of the criminal justice system, I hope we think long and hard about abandoning the Reagan-era tough-on-crime legislation, because it's made our community safer, in my opinion, and saved thousands of lives over the last 30 years. Thank you.
Thank you. I had hoped to have more time. I asked Diane Kozub and Matt Kazmarek if they would go confer with Judge Jones and Justice Thomas about them giving us more time to speak to you and take questions, but they shot me down on that, I think. And so I think we're right at 12:20, is that right? Okay, well, I'm sorry we can't take questions, but thank you all. It was a wonderful panel. We very much appreciate it.